No to racism. No to intolerance. No to racial profiling. Repeal SB1070 now. No to racism. No to intolerance. No to racial profiling. Repeal SB1070 now. No to racism. No to intolerance. No to racial profiling. Repeal SB1070 now. No to racism. No to intolerance. No to racial profiling. Repeal SB1070 now. No to racism. No to intolerance. No to racial profiling. Repeal SB1070 now. No to racism. No to intolerance. No to racial profiling. Repeal SB1070 now.
Section C provides for the transfer of any non-citizen who is unlawfully present to federal custody upon discharge from prison or assessment of a fine after conviction of a state offense. Explanation. This law is unnecessary as to any person who is booked into a jail or serves time in prison because federal law already provides for a process by which individuals are checked against law enforcement databases and immigration holds or detainers can be placed on persons who are identified as non-U.S. citizens. A detainer ensures that the person will be transferred to federal custody instead of being released. Section D provides authority for state and local law enforcement to transport non-citizens in their custody suspected of being unlawfully present to federal authorities, even outside the jurisdiction of the local agency. Explanation. This law is unnecessary as to any person who the federal government has reason to believe is in the country illegally because the federal law already provides for a process by which those persons can be transported to federal custody. Local agencies can also contract with federal authorities to be reimbursed the cost of detaining and transporting such persons. The only reason why this provision seems to have been included is to permit local law enforcement to transport undocumented immigrants to some point of transfer other than the local Immigration and Customs Enforcement Agency office. ICE is, for whatever reason, not interested in taking custody of the person. Section E gives police officers authority to conduct warrantless arrests of persons for whom the officers have probable cause to believe have committed any public offense that make those persons deportable. Explanation. To the extent that provision attempts to create a state arrest authority for administrative violation of federal immigration law, it is likely to be deemed invalid by the courts because states cannot create such arrest authority where it does not exist under federal law. As the Ninth Circuit held in a case from Arizona called Gonzalez versus City of Peoria, while Arizona could authorize Peoria to enforce the criminal provisions of the immigration law, and I quote, "We firmly emphasize that this authorization is limited to criminal violations," unquote. The court took issue with the Peoria Police Department policy because it obscured the difference between civil administrative violations and criminal violations of the immigration law. And as the court stressed, the lack of documentation or admission of illegal presence, quote, "does not, without more, provide probable cause of any criminal violation," unquote.